Good afternoon, ladies and gentlemen, and welcome back to the Public Service Commission of South Carolina. We are here in docket number 2020-263E. Let's take roll. Present in the hearing room, we have Commissioners Thomas, Powers, C. Williams, Belzer, and J. Williams. Joining us virtually, we have Commissioners Irvin and Commissioner Caston. Excuse me, 1 second. All righty. Cherokee Council, are you ready to proceed?
Mr. Chairman, before Ms. McGrath proceeds, if I could just briefly just update the commission on some scheduling matters. I did confirm with Ms. Bowman, who is the company's fourth and final witness, that she would be available to extend past 6 o'clock this evening, which was the previously scheduled end date that the company, or the commission, excuse me, identified. So if the commission prefers to soldier on this evening past 6 o'clock, the Duke companies would be available to do that.
Okay. I have to consult with the team before we make that type of a decision. If it were up to me, we definitely would soldier through it. Let me ask the other parties, does anyone have any responsibilities this evening? Child care, parental care, happy hour?
Well, let's talk about that, Mr. Chairman. Are all of those considered? No. The Cherokee Council are certainly available, and others are available to go past 6 o'clock tonight, if that suits the commission.
All right. Definitely got to get with my staff before we make that decision, but I hope that we can finish witness Snyder today. All right. If there's nothing else, let's continue.
I think you're on mute.
Thank you very much, Mr. Snyder. I appreciate that.
You're welcome,
thank you,
Ms.
Mr.
McGrath.
Chairman.
Done it many times.
Before I start speaking with Mr. Snyder again, would you like me to move in my exhibit from the first part of my examination?
Yes, and speaking of exhibits, I think General Counsel Wessinger Hill has a few announcements to make. You may enter your exhibit as soon as she finishes.
Certainly.
Thank you, Mr. Chairman. With regard to the late filed exhibit requested by Commissioner Carolee Williams, parties, that's going to be denominated as exhibit number 13. And then the comments, responsive comments that Cherokee County Cogeneration's Council had requested, that will be denominated as exhibit number 14. Did I say that right? I hope I did. Okay, thank you.
All right, Attorney McGrath, did you have a exhibit you would like entered into the record?
Yes. If I could first move exhibit number Snyder 001 into the record, that is the Duke Energy Investor Update presentation. Is publicly available from Duke's website, its investor page. I believe Mr. Snyder said that he would accept my representation that that's what it was, subject to check.
All right, Snyder Exhibit 001, Snyder Cross Exhibit 001 will be entered into the record as hearing Exhibit 15.
Oh, and Mr. Chairman, I'm sorry. This is Joanne Wessinger Hill again. I made a mistake on my numbering. It should be late filed exhibit requested by Commissioner Carolee Williams is 14, and the responsive comments from opposing counsel from Cherokee would be item 15. So the next exhibit, which is this one, would be hearing Exhibit 16. I apologize, Mr. Chairman.
No problem. So Snyder Cross Exhibit 001 will be marked and entered into the record as hearing Exhibit 16.
And Mr. Chairman, if I could also enter Snyder Exhibit 002 this was the one that, it's in my pre-filed exhibits with the commission, but I had a hard time emailing it. I think Mr. Snyder was familiar with the DEC IRP from 2020. That's publicly available as well from the commission's docket.
All right, Snyder Cross Exhibit 002 will be marked and entered into the record as hearing exhibit 17.
Thank you very much, Mr. Chairman.
Okay. Attorney McGrath, give me 1 moment. I beg your indulgence. Witness Snyder.
Yes, sir, Mr.
All
Chairman.
right. For some reason or another, we cannot see you. Well, we see you now. All right. Please proceed.
Thank you very much. Nice to see you again, Mr. Snyder. Did you have a nice hour with my exhibits?
I did have a chance to review them. They were more extensive than an hour would allow me to read them in depth, though. So,
Of course, I expect that you're familiar with some of them and that we can get through this
Yes.
fairly quickly. Now, I was about to ask you about loads. We talked a lot about how you treat resources and particularly third-party PPAs for purposes of your IRPs. Now, you also have a different type of contract. You have supply contracts with wholesale power purchasers. You treat wholesale power contracts like they would drop off when they expire as well, don't you?
I think I know where you're going, but I just want to be clear because depending on which perspective, supply can mean two things. So we're talking about contracts for the purchase of power and contracts for the sale of power. Is that okay if we use that nomenclature so no one gets confused, Ms. McGrath?
We can, yes. You have customers who purchase power from you via contracts that do expire, correct?
Yes, we have wholesale power commitments that we sell to municipals and cooperatives throughout North Carolina and South Carolina over generally long-term contracts that are represented in our IRPs. Those are sales contracts, yes.
Sure. And those do have expiration dates typically, correct?
Typically they do, yes.
And I think you probably saw in my exhibits, but perhaps we can skip entry of the Central Electric RFP. We had reviewed, I'll represent to you that we reviewed your load data, and we took a look at your contract with Central Electric Cooperative. Are you familiar with that contract?
Generally, yes.
Okay. Are you aware that it begins rolling off in the years 2028 and 2029, correct?
That is correct.
And but you continued to model Duke serving that load beyond the contract expiration, correct?
Yeah, we consistently model sales obligations, most of which are pretty long-term wholesale obligations for municipals and co-ops that Duke has served for, a number of years. We do continue to show that need in the resource plan.
Okay. And you continue to show that need in your resource plan, even though I think you saw in the exhibit, Central Electric, your large wholesale power customer, has issued an RFP seeking to replace Duke as its wholesale power purchaser. Is that right?
That is correct, yes.
Okay. So you do, just to be clear, you treat the expiration of QF contracts completely differently than you do for contracts for load you serve, correct?
Yeah, from a planning perspective, again, I think it's important to put it in context of an integrated resource plan. So in an integrated resource plan, a purchase from a QF or any other power provider, wholesale power provider, is a resource that we have contractual rights to for a certain point in time. And that resource then, at the expiry of that contract, may or may not be renewed. And so we do exclude that. Wholesale providers, or wholesale contracts, which we provided in a lot of cases for, many number of years, generally don't have alternate resources other than what they don't have their own resources. So they may go out for an RFP as part of renegotiation with Duke. Our history has been that they usually do that and then renegotiate with Duke. Importantly, from an IRP perspective, if that wholesale contract does not extend, we have those undesignated resources that you and I went over with that would just go away with those. So if Central came back and said, you know what, Duke, we know we normally re-up with you, even if we go out for an RFP, we're going to go away, then my first need date will go further out in time for Cherokee, because I will remove that undesignated resource that's at 2028 need. I would take that out of my resource plan. I haven't committed to it, haven't asked for a CPCN for it. It would come out of my resource plan, the load would go away, and I would still be able to reliably serve my residual load that's in the resource plan. So if job one of an IRP is to maintain reliable service, there's a big difference between a long-term wholesale customer that you've served for a long number of years who doesn't have its own resources, in all likelihood is going to end up buying from you. And if not, you're going to pull out the resources, the undesignated resources that were commensurate with that load, and still reliably serve load. A purchase power obligation that is serving contracted retail and wholesale load today going away has a much different implication in an IRP and a much different market. So yes, the history of serving munis and co-ops and how that impacts a resource plan and what the impacts of that cancellation would mean and how the levers and tools you have to deal with that are completely different on the supply side versus the demand side, or in this case on the purchase versus the sale. I would, end with, if they were to go away, then your 2026 need date, 2028 need date, all of that's going to reflect the load going away. So it actually benefits the QF to continue to have that load in the resource plan.
Well, yes, of course it benefits the QF to continue to have that load in your resource plan, but it would also benefit Duke because it would justify further capital expenditures that you may not need if the load drops off. Isn't that correct?
We would not build for them unless we were sure we had to serve them. So their RFP is, I think the document you sent me was for 8 or 9 years from now. So we could either not build for them, or we could retire resources that we currently would plan to have to build to replace. Our IRP showed a lot of coal retirements that require immediate replacement. We could retire those coal units and wouldn't require the CTs to replace them. All of this would push out that first need date. But again, there's a fundamental difference in resource planning, and there's just a fundamental difference in the market between supply contracts, which we have hundreds of, and the long-term wholesale municipal and co-ops that we've served for, for many, many years.
Understood, Mr. Snyder. Thank you very much. I would like to turn to your most recent IRP proceedings. Both South Carolina and North Carolina oversee your IRPs. Is that correct?
If you mean, do they get filed with the commission and are they part of regulatory proceedings? Yes, they are.
Mm-hmm. And you recently filed your IRPs in both the South Carolina and North Carolina commissions in about fall of last year. Is that right?
Yes.
Okay. And both of those commissions have not accepted your IRPs at this particular time. Is that correct?
Generally, South Carolina has asked for certain modifications to be made, which will be filed forthcoming, assuming I can get off the stand.
hearings on your IRPs as well. Is that right?
They issued an initial notice saying that they are going to come forthcoming with specific issues they would like to have more information on. I don't know if that's going to take the form of hearings or technical conferences. We will see what the order says.
Okay. Yeah, and both of those proceedings had some pretty robust intervener engagement, didn't they?
Our IRPs have very robust intervener. Yes.
Okay. And both in North and South Carolina, I assume you're familiar with the concerns raised in those dockets. Correct me if I'm wrong, but it seems like interveners in both had a huge problem with a very large amount of new gas build in that DEC's models have selected. Is that fair?
It was a subject of some debate, certainly in South Carolina, and I would note all of that is undesignated, except for the Lincoln CT that we just had a fairly lengthy discussion on. So all of that new gas build is an undesignated resource that does not push out the new date. So that issue, I guess what I'm trying to say is that issue really, as I'm trying to think through it, would not impact this need date. It would change the resource they might like to see, but it wouldn't change the need date.
Okay, except for those very large, shiny new Lincoln CTs, right?
The ones that we have a CPCN that have already been fully litigated, that were done at well for the Cherokee costs, yes, those ones are not included in my statement.
Understood. So I'd like to just take a look at the order that South Carolina issued, and I'm not going to enter this as an exhibit. I will request judicial notice. Allow me to pull it up here. And just as a reminder, the IRPs provide that critical input into the avoided cost calculation that need date for your next capacity addition. That's correct.
Yeah, that is one of the big inputs, is that need date.
Okay. Allow me to. So, Mr. Snyder, do you recognize this order? It's the order requiring modifications to integrated resource plans. I believe you mentioned it yourself.
I do recognize that.
And are you okay with my representing that this is a correct copy of that order?
I am, yes, subject to check. I'm fine with that, but yes, I'm sure it is.
Certainly. Thank you. Now, right in an introduction here, we see that we have found several deficiencies in your IRPs that you filed in 2020, correct?
That's what that says.
Yeah. And I just want to go to the standard also that this commission uses when it looks at your IRPs. So Act 62 added a requirement for IRPs that the IRP plans represent the most reasonable and prudent means of meeting the electrical utilities energy and capacity needs at the time the plan is reviewed, correct?
Yes, that's what Act 62 says.
Okay. And I'm just going to skip down to the recommendation section. I'm sure you're very familiar with this and working on it diligently at the time. It looks like these are the ordering paragraphs. There were, is it correct that there were recommendations to be included in future IRPs, Mr. Snyder?
Both the modified and recommendations for future, yes.
Right, and there were about 10 deficiencies that the commission identified that were, so deficient that they wanted you to refile your IRPs with pretty significant modifications to your assumptions. Is that fair?
I wouldn't call them significant. I would say they are modifications. I think there was some debate as to the significance of them. So I say there are some modifications. I don't know that it's going to have dramatic changes to the resource plan, but there will be some changes, yes.
Okay. Well, I mean, you won't know that until you run your models, correct?
Well, if you'd like to point me to any of these that you believe is going to have a significant impact on the first need date, I would be happy to walk through that with you.
Okay, I don't think we need to belabor the point. I do believe there were, particularly some assumptions about gas forecasts that may impact your. Here we go. That may impact avoided costs. So they did not take your recommendation and found you were wrong with respect to natural gas pricing forecasts. Is that right?
I don't know if they'd say wrong. They wanted to see a portfolio run with 18 months of market and to put that in and show what that would do to the IRP, and we are fully intend to do it. I would say that will not change the first year of need date, and that's a very separate issue from whether that's appropriate gas price forecast to use in avoided cost. So we will fully comply with this order. We will do that in the IRP. We will show those results, but that is distinct and separate from that issue in an avoided cost docket. It's also distinct and separate and has really no impact on the first year of need date.
Okay. But it would impact avoided cost, wouldn't it?
Potentially, if the commission wanted to use that in avoided cost, to ask for this in the IRP and see how it impacts the portfolio is a very different request than to use 18 months when you're actually setting rate. The IRP does not set rates. The avoided cost sets rates. And so we are entering into 5 or 10-year PPAs, and the appropriate gas price to use in avoided cost would need to be litigated in an avoided cost.
Sure, and you have that coming up next week, correct?
We do.
Okay. And I just wanted to go over to your testimony on this point. This is Snyder 012. It's your rebuttal testimony from the IRP docket, and I just wanted to kind of put in context what you recommended. Could you read the title of that section for me, please?
The company's natural gas price forecasts are reasonable, and CC the witness Lucas's recommendation to deviate from near-term market price should be rejected, as it would expose customers to significant future avoided cost overpayment risk. Page 62.
Okay, thank you very much, Mr. Snyder. And just to be clear, the commission disagreed with you on that point, correct?
No, I don't know if they disagreed with me on that point. They simply said run a modified IRP that looks at the impacts in the context of an IRP, how it would impact your resource plan. And we fully intend to do that. Whether the commission would make that same determination if it was determined that we should pay 18 months rather than 10 years of gas to a QF when a 10-year visible gas market is available is a determination for the commission to make in a separate docket. But they did ask for this in this proceeding, and we fully intend on providing that.
Okay. And did the commission ask you to make changes to your assumptions with respect to capital costs for battery storage resources?
They did ask for us to see the impacts of using the NREL low ATB case, yes. And
that would significantly impact your potential avoided costs first capacity need date, or no?
No.
Okay, but it might affect might affect what? I'm sorry. Go ahead, Mr. Snyder.
No, I'm sorry. The need date is when you don't have enough generation to reliably meet load and meet a 17% reserve mark. The cost of the resources then say what is the most optimal resource to replace that or to meet that need. So changing the price does not impact the need date. It changes potentially, and we're in the middle of running that, but it changes potentially the resource that gets selected to meet that need.
Okay, and that could very well impact avoided cost calculations, couldn't it?
It would lower them.
Okay. we've talked from a few different angles. I'll go ahead and stop sharing that screen. We've talked from a few different angles about how the IRP feeds into avoided cost calculations. So I think, is it correct, Mr. Snyder, that you recommended in the IRP proceeding that the commission not require you to make modifications to your IRP?
I think we recommended that and it might be more appropriate in an update, and the commission decided to have us do it in a modified.
Mr. Chairman.
Okay.
Commissioner Powers.
Mr. Chairman, I hate to interrupt any attorney, and I realize this is cross-examination, but I'm kind of wondering about the relevance of some of this IRP stuff. And, unless there's a smoking gun, maybe she could get to a point with some of this.
Counsel.
Understood. Thank you, Commissioner and Mr. Chairman.
Oh, no, I'm wondering, why are you talking about the IRP so much?
Because it impacts the first need date, which is central to the avoided capacity cost payment to Cherokee. So apologies if I did not kind of loop back to that, but the point is that, the South Carolina Commission has identified significant deficiencies in the most recent IRPs, and Duke relies on those for its avoided cost offers. So if the IRPs are faulty, then the avoided costs are likely faulty as well.
And Mr. Bright, sorry.
Mr. Chairman, I understand the practice is open cross in South Carolina, and I've tried to, there is some tenuous connection to the avoided cost calculations. I would note that Cherokee's argument from the beginning of this case has been that they're deserving of September 2018 avoided cost rates, which were calculated well before the 2020 IRP was filed, before Act 62 was enacted. So I agree with Commissioner Powers that the relevance of this line of questioning is tenuous at best, and I think there's a full record in the IRP docket as well as in the avoided cost docket, which goes to hearing Monday, that Cherokee has not intervened in, which will fully vet the methodology that the company uses to calculate avoided costs in South Carolina. So I would object perhaps later than I should have on those grounds as well.
The objection is sustained, and I'm just not one for telling a lawyer how to try their case. But as I read through the complaint and understand the allegations, I too have a little bit of trouble connecting the 2020 IRP to an issue that arose in 2018. So, Counsel, if you would please move on, we would greatly appreciate that.
Certainly, Mr. Chairman, apologies for lingering too long. Can I turn to the 2018 IRP then, please?
Sure.
That is the one, again, that our avoided cost offer was based on. I mean, we're getting to the point here that, Mr. Snyder, you're aware of Act 62, correct?
I am.
And you are aware that Act 62 completely overhauled the IRP process, correct?
I would say it added detail to it. We filed IRPs long before Act 62 that look very much like the IRPs we filed after Act 62. So yes, it overhauled the regulatory approval process of them, but we have had a practice of putting very robust IRPs before this commission for a number of years. And I would say Act 62 overhauled the commission's role in the review of those IRPs.
Right. So the commission did not have much of a role in reviewing your IRPs in 2018, did they?
The South Carolina Commission, I believe, was given an ex parte briefing on it, and it was filed and reviewed with lots of discovery in North Carolina. So yeah, that has changed. Now South Carolina also has lots of discovery.
Okay, but it wouldn't surprise you, Mr. Snyder, that there is no order in that docket, in the 2018 IRP docket approving your IRP.
It would not surprise me in South Carolina that there was not an order approving it, since that was prior to Act 62.
And Mr. Snyder, it looks like there were very limited interveners here compared to what you have in your current IRP docket. Is that fair? Is that correct?
If you're speaking of just South Carolina, I think that's a fair statement. We had, as I said, significant intervention in North Carolina with many of the same interveners.
Okay. And North Carolina and South Carolina occasionally come to different decisions on matters. Is that correct?
I'm sure they do.
Okay. So no one really closely reviewed your 2018 IRP, did they? At the South Carolina Commission.
Like I said, we filed it. We have done ex parte briefings. To my recollection, we usually do those. Trying to remember if we did one for 18. It was the subject of, like I said, great discovery in both the North Carolina IRP case, but then also as the basis for the 2018 avoided cost filing that we made in North Carolina. So many of the issues we're talking about today, first need date, gas curves, all of this were heavily litigated in North Carolina as it relates to our IRP and avoided cost.
Okay, in North Carolina. So Cherokee had asked you for data underlying your avoided cost rates, and they didn't receive anything associated with your IRP. Is that a fair statement?
No, I was not part of that request, but as I understand it, we did respond to them, explained how we calculated avoided costs, gave them here's the method we use, here's how we approach avoided cost, here's how we came up with this pricing. And if I remember Mr. Keene's testimony, 10 months later, they came back and said, we want more.
All right. Well, when you have a retail rate case, your rates are cost-based, you said. Do you just kind of do your customers take your word for it, what your costs are, or do they really ask you for the receipts for those and really dig into the cost basis for those?
Yeah, I think they dig into the cost basis much the same way we file avoided cost cases that go through extensive discovery, both on the process, the methodology, the inputs, the year of need date, and that is heavily litigated, much discovery. And then we continue to utilize that process and then just update inputs with our large QFs as a manner explained by Mr. Keene.
Okay. Thank you, Mr. Snyder. And so just to kind of recap, this commission did not approve the 2018 IRP. This commission did review your 2020 IRP under a pretty robust new procedure and found a lot of issues with it. Is that fair?
Like I said, you put those up quickly and took them off, and all of those I think would serve against your client. By most of those, in fact, we had interveners saying we should have a lower reserve margin. That would push out the first year of need. We had interveners saying you should be forced to do more renewables or give more capacity credit to renewables, which would then also push out our first year of need. So there's a lot of debate in the IRP. It's unclear to me which one of those recommendations is going to accelerate the first year of need, if not push it out. So, it is a IRP that we will meet the expectation of the commission and file here shortly. But I don't see it being, that outcome I'm just looking and thinking through all the pieces of that, and I can't see any of those that are going to be fundamentally germane to the offer made to your client, and notwithstanding the fact that you're arguing that we should be looking at 2018 in some respects, and then 2020 in others. So, but yes, we will have a new IRP filed, modified IRP filed, pursuant to the commission's order.
I guess my point, Mr. Snyder, is that, I'm not here to, fly spec your 2020 IRP, but your entire case rests on your avoided costs and your first avoided capacity need date being correct. And no one has reviewed that from the commission, and no one was able to review it from LX Power.
Mr.
Oh,
Chairman.
I think that's
So-
incorrect.
Mr. Snyder, excuse me for a minute. I'd object that there was no question there. I think that was an assertive statement of testimony by counsel, and I'd ask that the examination of the witness be in question form and not testifying by counsel.
Sustained.
I will withdraw. I have no further questions for this witness.
Office of Regulatory Staff. Office of Regulatory Staff. Commissioner questions.
Chairman Williams.
Commissioner Caston.
Afternoon, Mr. Snyder.
Good afternoon, Commissioner Caston.
Commissioner Caston.
Yes, sir. Oh. I look better with it off, but I'll turn it on. Sorry. I want to circle back to a question that Commissioner Thomas asked another witness earlier, because it's still on my mind. Is it normal for a QF, I guess, to guarantee the same capacity to separate utilities?
No, it's not, and it's just physically not possible. I'm not aware of any QF that's even, there seems to be some after the fact sort of revisionist history that suggests maybe they were going to split it, even though that was never mentioned in any of their communications. It was always the full output. I'm not aware of anyone splitting and selling to two different, nor is it possible to fully commit your output to two separate entities simultaneously if it's truly a commitment.
And I think earlier when we were talking, you asked about fuel cost and other things such as that. If you said were pass-throughs, if I understand that, the cost of energy that you purchase from a QF, whether it's Cherokee or whomever, that cost is passed on to the customer, correct?
That's correct, sir. It's passed on to the using and consuming public.
So there's been discussion about RFPs, avoided costs, and a host of other things. And it seems to me that the question is, just relative to the LEO, is it established, whatever that date was, September 2018, is that an established date number?
In my opinion, it is not an obligation. It was an intent. And I think, when I said, I know there's lots of views. This gets litigated in multiple jurisdictions. I think it's been brought up to FERC before on what does constitute a non-legal or non-contract legally enforceable obligation. And so clearly there's a difference of opinion in this proceeding, and Ms. Bowman can speak to that in more depth than myself. But, to me, it has to be much closer to a true obligation and not an open-ended offer simply to hold a price while you're shopping through time and across utilities. Because there is no obligation at any point to this point in time. At this very moment, if Southern Company said, hey, I want to pay you a premium for your power plant, will you sell it to me? There would be nothing we would have no ability to say you've obligated it to do. They could turn around tomorrow and sell that power plant and have that power go somewhere else. So to me, that date was not an obligation. And even if it was an obligation, it would have expired when they refused to purchase at the utilities avoided costs.
And I'll say, I guess, those kind of questions for the later witness. Are you aware of any other QFs in the Duke system that requested LOEs? Well, let me back up. And this is probably a question for the attorney too. As I understand, this was about 30 months before the end of the contract.
Yes, it was about that time.
If they had chose to do it 48 months or 60 months before the end of the contract, does that establish a date?
And that's where, I'm sorry, Commissioner, I didn't mean, I'd let you finish.
Well, I'm asking you a question that probably needs to go to attorney. Have you experienced, has Duke experienced any other QFs requesting this that far in advance of the end of the contract?
I will say not to my knowledge, with the big caveat that that is not, I'm not the commercial person that deals with these, every one of these. So it would be just my personal, I'm not personally aware of any. And to your earlier question, I do think that's where clarity could certainly help in terms of how far in advance is too far. One of the things I'm concerned with is term of contract, but if there isn't no limits on it, then term of contract is a moot point. I could simply enter into a 10-year contract, 3 months later, submit my Leo for the next 10 years and establish a 20-year contract. And that obviously would be a circumvention of what's intended to be a 10-year contract. So, what is a reasonable date in advance of the expiry of the contract, I think, should be much closer. I think we are on the edge of where I think is from a QF and PURPA policy, we should go at 30 months. I would certainly not want to go any further in advance in establishing a Leo. But I will say, finally, on that question, we did offer them avoided cost pricing and did not say it's too, just like we were offering everybody else at that time. And again, at that time, we were being inundated. And so everybody was getting the same avoided costs, the same form, the same price who came in at that point in time. And if it was a month or two later, they were getting the prices that were calculated under the same method at that point in time. So, we did not impede their ability to get avoided cost pricing. We didn't say 30 months was too far in advance, but I certainly think we would not want to go much further in front of that than we just did in this case.
Thank you, and I'll ask that question later. Thank you.
Thank you, Commissioner Cassidy.
Commissioner questions? Witness Snyder, I got a couple questions for you. I'm going to try to make this quick. Under Purpose, is there any consideration for the past relationship that Cherokee had with Duke regarding providing power?
No, sir, not to my knowledge. That PURPA, we would treat whether this was a 20-year contract or whether there was a identical version of Cherokee that came to us that was a brand new facility, they would receive the same pricing.
Is Cherokee entitled to any different treatment because they are a dispatchable gas-fired plant as opposed to a solar QF?
I think they're entitled, if they want to ask for dispatchable pricing, it's a form of contract. I think they have served us under both forms. They can ask for that, but in terms of a higher price, a longer term, more preferable treatment in other aspects, no. So I would say in most aspects of the contract, they are not. If they want a different form of contract, they are entitled to ask for that.
And when asked, did Duke respond to their request about a different form of contract? Because I've heard two definitions for negotiation. Negotiation regarding the actual avoided costs, which I understand the company's position is you can't negotiate the avoided cost, it is what it is, and then negotiation about other commercial terms in the contract.
Right. And I tried to review Mr. Keene's testimony, and to my knowledge, the counteroffers that were being made had many things going on. It wasn't just the form of contract, right? So they were longer term, they were higher price, and they were dispatchable. But to my knowledge, I don't recall Cherokee ever saying, I would like your avoided cost for a 5-year PPA. That was what was being offered at that point in time. I would like your avoided cost, not in a must take, but give me a 5-year PPA avoided cost as a dispatchable. That request never came. Instead, they had a longer term at a higher price, as I review Mr. Keene's testimony. So I think, that's where is that longer term higher price then implicitly saying you should have come back with a 5-year dispatchable. I'm not the commercial negotiator, but it certainly doesn't seem like they ever requested that.
Well, if there was a disagreement about the avoided cost, wasn't that known during the first attempt at negotiation?
Yes, I believe, and again, in reviewing Mr. Keene's, that when counteroffers were proposed, in some of the exhibits that were put up earlier, I think Mr. Keene company responded with, your counteroffer is above avoided cost, and so we're not allowed to pay this price under PURPA. So the difference in our view of avoided cost and Cherokee's, and primarily comes down to them asserting that they should be paid for capacity starting in year 1, drives most of that difference. But that was known that their counter proposals were above our calculation of avoided cost very, very early on in this process.
So, and I know you're not in their head, I'm just asking your opinion. You're up here giving expert testimony. Why do you think they would wait so long to bring the matter to us?
I don't want to say their exact motivations. I will say it from the standpoint of what the end effect is it leaves a long time open where you can look at prices across time, and the end effect, whether it was intent or not, I'm not here to say, but you can then go back and say, this is where I think I was entitled, because I got a lot of looks at prices over a 3-year period. And my view is, if the view is then the earliest one was the best, then I go make my case around that. If today's was the best, I make my case around that. And, ironically in all of this, if you get away from the zeros issue and say 28 versus 26, the most current price on a 10-year dispatchable is probably the highest price that goes across all of those dates. So Leo is only an issue if you are ascribing the Leo to say we should pay for capacity whether there was a need or not. If you go with the 28 date, the 20 date, the 26 dates, you know, the 5 offers that Mr. Froy and Mr. Keene spoke about, I believe the most recent price is the best and highest price on a 10-year dispatchable, and it would actually behoove them to take the most recent, because I think if we went back and calculated a 10-year dispatchable in 2018, we would come up with a lower price.
So that price is still available right now. What you opine is the best price.
Yes, in my opinion, and again, I'm probably getting in trouble with my lawyers, but that's nothing new.
Don't get in trouble with. I'm not asking you to get in trouble with your lawyers.
I'm just saying, I think it is, because I think when they filed, you know, we're not going to attempt, they filed a complaint with this commission. Time has passed since then. When they filed the complaint, I would say that is the time we should use for what were the prices available at that time. That is available now. We would, I am confident we would execute at those prices as we sit and breathe today.
All right, thank you, sir. No further questions from me. Commissioners.
Mr. Chairman.
Commissioner Irvin.
Thank you. Mr. Snyder, good afternoon.
Good afternoon, Commissioner Irvin.
In following up on the last question and answer, let's assume that, and you can confirm for us, I don't have the pricing in front of me because it was a confidential exhibit and I don't have it up on my screen, but you can confirm for me that the last offer was the highest and best offer.
I will, with my understanding in talking with our structuring folks and our commercial, if you use the inputs that we had and agree that, you know, we're talking about the benefit of a 28 versus a 26 first need date, that the increase in capacity payments by accelerating that need, as Mr. Freund spoke about, and raising the cost of the turbine, those two factors will result in a higher increase than any small decrease that may have changed in the energy value, so that the net price on a 10-year dispatchable contract is the highest and best. If I were to do that across all those LEO dates, would be December, or would be the DEC February 2021 offer.
And so, having established that, Duke Energy Carolinas is ready, willing, and able to offer that PPA, 10-year term, to Cherokee now.
Yes, sir, Commissioner.
And so, if the commission decides to deny the petition and dismiss the Cherokee's request to establish a LEO back in time, how would you propose that the commission deal with the overpayment issue in terms of a true up for ratepayers?
I think there are many options available to the commission. You could take the current price versus the extended contract price, the price that the commission and the company ordered, take the difference between those, and you could allow that to be a slight discount over the next 10 years, such that Cherokee did not have to come up with it immediately. You could order immediate payment of it. You could allow the company to execute its whatever by the time this order's out. As I understand, Mr. Keene, we will have hopefully based on negotiations, letters of credit in place. You could draw on those letters of credit You could return, as I said, return the letters of credit and just have a slightly discounted price over time. So I think there are ways to ensure that the customer's kept whole on that, and it would just be multiple mechanisms you could consider.
And is Duke willing to work with Cherokee to negotiate terms that would keep them in business, so to speak?
I think that's the big question in the room that we're all struggling with. Is it's really unclear if Cherokee, if at our avoided cost at our highest and best offer in February, if they can operate the plant at those costs. I think Mr. King testified that it was his hope that they could. And Cherokee may have a different opinion. I'm sure you'll hear from their witnesses tomorrow. But, we would, when it comes to things like, how the letter of credit's disposed of, or how the overpayment, or other terms and conditions that might help Cherokee, it's certainly the company outside of its limitations to offer avoided cost would work in a commercial best efforts manner to ensure Cherokee could stay in business.
And I don't know much about letters of credit, but I assume there's a cost associated with coming up with a $6 million letter of credit from a financial institution. There's a substantial cost that would have to be paid up front, correct?
Yes, I don't know at today's interest rates what those costs are, but it is my understanding as well that you don't get an LOC for free. Rates are fairly low now, but I do not know what that exact cost would be.
So in terms of
short-term debt instrument.
Yes, sir. And so it might be more beneficial if Duke was willing to work with the company to spread it out over the 10-year term at a slightly reduced avoided cost rate, correct?
If Cherokee's desire, I think, the company would, and again, I am dangerously treading on Mr. Keen's role here. I've spoken for my lawyers. I'm speaking for my commercial, but I would think that would be the how we collect the overpayment would be something we would have some flexibility in, assuming it was acceptable to this commission.
Yes, sir. Thank you. I have no further questions.
All right, redirect.
Mr. Chairman.
Oh, I'm sorry. Commissioner Thomas.
Quite all right. Good afternoon, Mr. Snyder. Good to see you again.
Good to see you, Commissioner Thomas. Good afternoon.
I have a couple of questions, and you're probably not the right person to ask, but you're the one up there right now, and I'm thinking about these questions. So, Duke is not the only source of income for the Cherokee plant, is my understanding, that they also sell heat or whatever it is to the Ready Ice company. So, they have another source of income. And I guess I'm wondering if the Duke customers get a benefit from that transaction. In other words, I hope the Duke customers are not paying for the gas and the transportation that you used when the output goes to the Ready Ice plant. Do you have any knowledge or information on any of those sorts of things?
I can tell you my understanding of how that would work within the PURPA construct, Commissioner, which is we offer our avoided cost rates not based on the cost or revenues that Cherokee receives, but rather the but-for or avoided value cost that they create for customers. And so it's really a true indifference price. Our customers are, if calculated correctly, and I know that's what's at debate here, but if calculated correctly, the customer is indifferent, but it's relative to Duke's cost of power. So if Cherokee or any other QF had other sources of revenue or could find ways to lower costs and could make, they're not, their margins are not regulated. So, there's been QFs across country that have done very, very, very well. making well, very good. And then at times when avoided costs go low, it can be challenging for them to operate. But that is on their side of the profit and loss statement, if you will, for them, and does not factor into our calculation of avoided cost.
Okay, thank you for that information. That's all I had.
Redirect.
Thank you, Mr. Chairman. Good afternoon again, Mr. Snyder. Just a couple questions. I want to cover two areas. The first is the conversation that you just had with Chairman Williams and Commissioner Urban about the relative benefits of a February 2021 avoided cost rate structure for Cherokee versus the September 2018 avoided cost rate structure. Do you recall that conversation?
I do.
Okay, and I want to point you to part of your testimony just briefly to confirm what I think you just explained to the chairman. All right, are you able to see my screen here, Mr. Snyder?
Yes, I am.
I'll make it bigger in a second. Yep, give me 1 minute.
We're going to get this after a few hearings.
Understood. I caught at this point. I just wanted to orient everyone. So this is page 33 of your testimony, and I'd like to focus on your figure 2. Do you see that there?
Yes, I do.
Okay. And can you tell the commission what this figure 2 represents?
Yeah, I believe that was actually from a North Carolina proceeding that may have been prepared by the public staff that just was looking at how avoided costs have trended over time. And it shows the steep decline over the last decade, but then a flattening in avoided costs in the last couple of years. And
okay.
actually maybe even a slight increase in that 18 to 20 period.
Right, and so the red line here is DEC. Is that
correct?
Okay. And
yeah,
so,
in discussion today, it's the red line we're looking at.
Right, and so I think this is the y-axis, if I recall correctly, but the cents per kilowatt hour, that relates to the value of the power. So would you say 3 cents per kilowatt hour, that's $30 a megawatt hour, and 4 cents a kilowatt hour is $40 a megawatt hour? That's generally how the math works.
That is how the math works.
Okay, so on your, what I would characterize as this is the annualized 10-year avoided cost as calculated by the public staff in North Carolina. They calculated, I think, as you just explained, the avoided cost in 2018 as pretty close to the $30 range, and it looks like this red line just ekes up slightly over time between 2018 and 2020. Is that fair?
That is fair.
And so your point to the commission earlier is, without looking at the confidential information which has been filed under seal by Mr. Keene, you can show that this February 2021 offer, the avoided costs on a generic basis are actually slightly higher in 2021 than they were in 2018.
Yes, on a generic basis.
Okay. All right. You also had some conversations with Ms. McGrath earlier about stop sharing my screen. The concept of a legally enforceable obligation and how you treat LEOs, so to speak, for IRP purposes. Do you recall that discussion?
Yes, I do.
Okay. And so the issue that I think she was asking about is in your recent IRPs, I can't recall if it was 2018 or 2019 or 2020 IRPs, whether you considered Cherokee and would have included Cherokee in the IRP if it established a LEO. And I think you initially said no, and then you clarified the difference between a contractual and a non-contractual LEO, or a power purchase agreement as a contractual LEO. Can you just explain that one more time to make sure the record's clear in terms of whether a QF can walk away from a notice of commitment?
Yeah, and I needed to clarify that because, as we've explained, you can establish a LEO by executing a PPA, or you can have a non-contractual LEO. And what it takes to constitute a non-contractual LEO is what's at debate in this proceeding. But I was trying to clarify that it isn't until we have an executed commercial contract and a LEO is established in that manner that we would include it as would include that QF as a designated resource in our IRP.
Okay, and if I could just share my screen one more time. So the issue, as you said, about whether or not a LEO has been established is a contested issue in this proceeding. And I think you were explaining that it matters from a resource planning perspective because that then informs whether your future IRPs and the resources you have available to serve customers, whether that generating facility is contracted, committed, or can sell to Southern Company or SCNG, Dominion, or to somebody else. Is that the issue?
That is correct.
Okay, and so this is, I'm not sure if you can see it, I'll make it bigger in a moment, but this is what was pre-filed as DEC DEP Keene Direct Exhibit 2 Attachment 2, which was accepted by the commission as Composite Exhibit 12, which is Cherokee's September 18, 2018 letter asserting an intent to sell to DEC. Do you see that there?
I do.
Okay, and so in addition to this letter, they also submitted what they called a South Carolina Notice of Commitment to Sell form for a QF. And that's been one of the issues in this case of whether this form established a LEO. Is that correct?
That is.
Okay, and so I think you addressed this in your testimony that they modified this form and it addressed whether or not they were eligible for Schedule PP here, and it clearly identified that they were not eligible for Schedule PP, but they were using the form for purposes of a non-contractual LEO. Is that your understanding?
That is my understanding.
Okay. And so in doing so, they're representing their QF, but they're also signing the form for the purposes of asserting a non-contractual LEO, which at the time was available to small QFs, 2 megawatts or less, that are eligible for the standard offer. And so my question for you, Mr. Snyder, is can you explain this paragraph 6 and how it informs the company's understanding of whether you can rely upon a non-contractual LEO in your resource planning process, and why you made the comment earlier that a small QF could walk away from a non-contractual LEO?
Yeah, I think, the subsection, the little I2, if the seller does not execute a PPA 30 days after the company's delivery of an executable PPA, the QF to the QF by the company that contains all the information necessary for execution in which the company requested that the QF execute and return. So it says, we're going to terminate in the first sentence if this executable PPA is not, and that's the point, is without an executable PPA, you cannot depend upon that power. So even in this small QF notice commitment form, it says that the notice commitment shall terminate if we don't get to an executable PPA, which is certainly the case here.
So in any circumstance, is a non-contractual LEO to the company's open-ended and would continue in perpetuity as suggested by Cherokee?
No, it's not, and it sort of can't be commercially, or it's really bad for customers.
Okay, thank you. That's all the questions I have, Mr. Chairman.
All right, Witness Snyder, you may step down from the stand. We're going to take a 5-minute recess. We'll be back, I guess 7 minutes actually. We'll be back at 6 o'clock. We're in recess until 6. All right, ladies and gentlemen, we're back in docket number 2022-63E. Let's take roll. President hearing room, we have Commissioner Thomas, Commissioner Powers, Commissioner C. Williams, Vice Chair Belzer, and Chairman Williams. Present virtually, we have Commissioner Caston and Commissioner Irvin. We considered going later tonight, but we don't think we can get through the next witness in an hour. So we're in recess until tomorrow at 10:30, and we will start with witness Bowen, I believe it is. Any questions from the parties?
No, sir. Thank you.
All right. We're in recess until 10:30. Thank you.